Erik Hovenkamp, welcome to Digital Markets Research Hub. Thank you for your availability, and I'm very glad that we'll have an opportunity to discuss various aspects of your scholarship, which is very impactful and rich. And my first question concerns your research on economics of antitrust law, primarily in the US, but it's broader kind of theoretical issue, which obviously has repercussions on many other jurisdictions, including the European ones. And the question concerns the economics or populism. So you argue in some of your papers that antitrust enforcement should remain tethered to economic welfare analysis. Please elaborate.
Yeah, our focus on consumer welfare is supposed to capture the fact that sort of more naive measures of sort of competition might fail to capture, what's really valuable to the public, right? So let me give you an example. Suppose that like Costco, a big chain grocery store, moves into a town, and you've got a handful of small grocery stores that go out of business. So the sort of populist sentiment might say, well, this is bad because we had these small businesses that were supporting a few people, whoever the mom and pops who run them, and now they're gone, and they've been replaced by this big company. Okay, but the economic approach to antitrust would say, well, consumers just switched to Costco because they liked it better. They get better prices, and people care about that. And so although the number of firms in the market went down, actually people are better off, right? Consumers are better off overall. So, that's kind of an example of how, when you by thinking about consumer welfare, we're ensuring that whatever we think is going to be best for the public is what we're going to try to do, and we're not just sort of going to protect small businesses just because we think they're sympathetic or something. If people prefer the bigger company, then that's not a bad thing. So what we should be worried about in antitrust is when a big company is able to drive small companies out of business, not because it's offering something a lot better than the rivals are offering, but because it restrains competition in some way. It sort of distorts the competitive process in a way where consumers feel obligated to go to the big firm, even though they don't like it as much as the little guys. So that's the thing that I think we want to worry about, and not just sort of this sort of populist sentiment that, it's bad whenever a big firm displaces small firms, right? If a big firm wins out over small firms just because people like what it's offering more, then that's not bad.
Okay, and obviously this is quite a categorical statement. So I wanted maybe to start with inviting you to elaborate a little bit on definitions. So you mentioned naivety and you mentioned populism. So it appears to be on the kind of at the extreme side of the normative schools addressing the issues of antitrust. I imagine there must be some middle ground. There are people who say that consumer welfare is a nice proxy, it's a nice benchmark which works most of the time, but there are situations where other factors, extra economics, or maybe those where the different metrics has been, different benchmarks have been used, have also some role. Do you criticize also this kind of middle ground approaches, or your criticism is focused primarily on the categorical, what you call populist approaches?
So I think, there are sometimes competing considerations, right? That things that, situations where the traditional consumer welfare story might not capture everything that we care about. So one thing that sometimes comes up is like national security interests might be in conflict with more traditional antitrust values. And I don't necessarily think that this is a bad thing. Privacy is another example. Like there might be a case where some privacy concerns sort of cut in a different direction than our usual economic analysis would normally cut. And again, I don't think that this is necessarily a bad thing. I'm not critical of an effort to try to bring other values into the analysis that we don't normally bring. But I think there needs to be some like good justification for it, right? So if someone says, well, I think big firms are bad, and I think it's bad when big firms, outcompete little firms, and we want to take the welfare of little firms into account. I don't think that's right? I think that we want markets to produce good results for the public, and the best metric for that is like, if consumers all pick the big firm because they like it more, then that seems like the big firm is doing something that that is good for society, right? If it's not restraining competition, it's just offering something desirable and people are picking that, then I think that's good. So I think that, ultimately we want to think about consumers and other trading partners of firms, and not welfare of firms themselves, big or small. That's not really the goal. I think that we should view markets as a tool that are supposed to work for us. And under that approach, I think you don't say, well, we're gonna suppress competition to protect little firms, because if that just means, well, you're going to make all the consumers worse off, then I don't think we're actually, that's not making the market work for the people, in my opinion.
So I imagine that there could be at least two approaches to criticizing extra economic consideration or extra consumer welfare considerations in antitrust analysis. One would be more kind of normative, on a normative perspective, where basically we are talking about the economies of scale and scope, and the bigness is not necessarily, or usually it's about the choice of consumers, and if they vote with their dollars, it means that the choice is somehow established. And another is more methodological nature, because law and economics gives us consistent thresholds by which, and pretty much universal, where things are commensurate and commensurable, and thus it becomes pretty much universal means to communicate with other jurisdictions, and it's transferable, so to say. Is your support of consumer welfare more of normative nature or methodological, or both?
I think these are both very important, right? So the first point is like, well, bigness is not inherently bad, because bigness is associated with like scale economies, which give you lower prices, and like network effects, like we see in tech, which brings higher quality, all else being equal. And so it's just not right as a matter of economics to say like anytime a market is concentrated that's worse for consumers. Like we've known this for a super long time in economics, right? That the best you can ask, like, what's the optimal number of firms to be in a market for, like what's optimal from the perspective of consumers? And in markets with strong scale economies or network effects, it's not infinity. Like you don't want an infinite number of really small firms. You want a smaller number of relatively big firms, which gives you the right balance between sort of how competitive the market is and sort of how like lower prices and how higher the quality of the products, right? So that's a key issue. And then methods are also a really important issue. Economics is, we have it's sort of a relatively objective intellectual framework. I mean, all of the hard cases are, people are going to disagree with each other, of course. So it's not a situation where everybody's going to reach the same conclusions, obviously. But we have like a relatively objective set of norms and principles that are empirically tested and that we think are reliable. And we have like the peer review process that can help to make sure that we are applying these ideas in a sensible way. populism does not really have anything analogous to this. I think populism, antitrust populism is really grounded in sort of moral and emotional sentiments that many people might have, but they're not really conducive to any kind of objective analysis, right? So there are a lot of people out there who think it's immoral for Costco to come into a town and displace small grocery stores. My moral compass tells me that there's absolutely nothing wrong with that, right? So if you were to, I'm not totally opposed to saying like, well, morality should play a role in some area of economic policy, but it better be the case that like we can agree on the relevant moral principles. If there's immense disagreement among whether something is moral or immoral, then it really does not sound like it's something that would be helpful to incorporate, right? Because, then it just depends on your perspective, right? So from my perspective, it's not very helpful to think of the, big business putting small businesses out of business as a moral issue, because, the best thing for the public is to just let them choose what they want. And if they choose the big firm, okay, it's not necessarily bad. That's my feeling.
And over the last 4 or 5 years, antitrust in the United States and in many other countries has become much more impactful, much more visible, much more present in the public discussions, and we can definitely see that its role has been increased dramatically, perhaps. I don't know if it's pendulous or it's evolutionary development. So I wanted maybe to invite you to highlight quickly on the state of affairs in antitrust academia in the United States. It looks that there is kind of a tiny minority of Chicago school adherents and post-Chicago law academics, at least. Maybe in the economics is slightly different, and the vast majority adhere to something which can be broadly defined as Neo-Brandeisian school or something of this nature. It's kind of more open to broader societal value antitrust. Is this perception a caricature of the situation in the United States?
So my impression is that only a small minority of academics are subscribed to the Neo-Brandeisian movement, I think. But you're right that it's also the case that not very many academics are sort of traditional Chicago people either. I think that most academics, both in law and in economics, subscribe to the sort of mainstream view that antitrust should be guided mainly by economics, but they also believe in imperfect competition and the economics of oligopoly and all of these things we've learned in the last few decades, which tell us that, that much of the Chicago school was inapplicable to, oligopoly markets. I think there certainly are some high profile Neo-Brandeisian academics like Lena Khan and Tim Wu, but I think they're still definitively in the minority as far as academics go. If you look at practice, like lawyers, you still see that there are relatively few Neo-Brandeisians, but there you see a lot more sort of traditional Chicago type sentiments. So I think the academy is definitely to the left of it, like the lawyers as a group at least, but still to the right of the Neo-Brandeisians for the most part.
And what's an explanation to it? Because intuitively one would suggest that the values of fairness and semi-political references to these universal values are more digestible for generalist judges, for example, and it is easier to convince them using the vocabulary of fairness and other societal values rather than refer exclusively to economics, hardcore economics. Why don't we see over the last few years the conversion of practicing lawyers into this broader, more open approach to antitrust?
Well, the boring answer is just that the case law wouldn't existing case law just would not support that kind of argument. But I think there's a more fundamental reason. So I think actually I would dispute your premise a little bit. I think judges are uncomfortable with legal doctrines that feel like they don't provide any real guidance, right? That are sort of too wishy-washy to really be applied. Okay, so a notion like fairness, you could potentially give fairness a concrete definition, but I think in general, as an economic matter, it does not really have a concrete objective definition. And so then what are you left with? Well, you're left with basically rhetoric, like people who can, describe their feelings about an issue, but there's no sort of objective test or criteria that we can use to really get at the right answer. Judges do not like that, especially like trial court judges who have to go through all of this hard work. They like things that are definite and rules that can be applied, right? To some extent, this is why judges really like the Chicago school stuff, because the Chicago School of Economics, well, it sort of feels objective if you treat it as true, but it's also like really simple. And so it gives you the best of both worlds, right? Like it's definite. It's not like so woolly that you don't know what it means, but it's also simple, right? And so I think that is something judges really like. Unfortunately, the economics of oligopoly is a lot more complicated than the economics of perfectly competitive markets. So mainstream antitrust is never going to be as simple as the Chicago school, but it's been a matter of consensus for quite a while now that like the world is just more complicated than the Chicago school believed.
Over the last 4 years, we've been witnessing the what you call antitrust populism, developing the ideas which are the ideological, closer to ideological center left, so to say. Now with the new administration, we probably see a much less consistent, whatever ideologically consistent approach, or maybe not. So let me invite you maybe to look at your crystal ball and engage in crystal ball gaze and suggest what should we expect in the following years in terms of, is it a new strand of populism, or it will be a neo-Chicago approach, or something in between, or something different?
Are you asking about like what this administration will do? Yeah, so it's interesting. There's a fair amount of rhetoric we're seeing from the head antitrust officials of the Trump administration that sounds fairly reminiscent of what you hear from Neo-Brandeisians, right? So Commissioner Mark Mador gave a speech a few months ago where he said things like, big is bad, like big companies are bad for society. I'm not sure like how long back in history you would have to look to see another Republican commissioner say something like that, but I'm sure like if it has ever happened, it was a very long time ago, because that is really not consistent with traditional conservative antitrust policy. So I think what we're seeing is, a little bit of a horseshoe situation. So like there's this old idea in political science that if you look at the far left of the political spectrum and the far right, they actually start to come back and closer together at some point. And so I think, this strand of anti-bigness populism is popular on both sort of the Trumpy right and on the progressive left. So there is some overlap, but there's also there are some distinctive aspects of, what you might call Trumpy antitrust. So, for example, the current FTC chair has indicated that he's very concerned with censorship by big tech platforms, which is pretty much a distinctly Republican talking point. The concern here is that, well, they say that big social platforms, that they are restraining conservative speech or discriminating against it. So I won't attempt to say whether that's true or not, but I will say that I don't think it's an antitrust issue. I think it's basically it's something that some conservatives like to talk about as a motivation for antitrust, but it's not really something that you could file a lawsuit based on. I guess to sum it up, there are some similarities between the current antitrust officials of the Trump administrations and the more left-wing populists, but there are also a few differences.
And it would be a nice moment to revert to one of the most high-profile cases, US versus Google search. And yet I wanted to pause. I'll revert to it in a minute, or that will be my next question. But I wanted to ask you about your paper on standard essential patents, which is a huge issue. Not many competition lawyers are dealing on a regular basis. Standard essential patents and patent pools, particularly in Internet of Things markets. Can you please highlight the key challenges and key things which you are dealing with in your research?
Yeah, so this is a really important area. So if you think about like 5G, the technology that most of the new phones run on, that's an example of a technology standard. So you should think of this as like a really big and complicated technology that many different firms contribute to. So it's imagine a big blueprint, and the little pieces of this complex technology are all made by different firms, and there's lots of different patents on all these different pieces of the technology. And so you end up in this situation where anyone who wants to use this new technology, like to use 5G, for example, is going to have to license like a ton of different patents, right? So patent pools are really important because patent pools make it much easier to license a large number of patents. A patent pool is basically, it's kind of like a little like Spotify. If you want to access a bunch of different music, you could just get Spotify and then you can access it all from right there. You don't have to go and transact separately with all of these different artists, right? So it gives you these network effects, these nice benefits. It's a one-stop shop, and so that's really important. So from a competition perspective, we often are worried a little bit about sort of what happens when a standard is adopted. Okay, so there might be multiple standards that are candidate standards, like 5G may have competed against some alternative cellular standard, right? And so at some point, one of them was crowned a winner. And at that point, all the patents on the rejected technology are worthless. And all the patents on the adopted technology are now super valuable because everybody's going to use this, right? And so there's this concern that there was competition initially, like between candidate technologies, but it's basically vanishes. And now you've got like something like monopoly power in these patents, right? And so there's a concern that people will exploit this by engaging in what's called patent holdup. So it means that people are adopting my technology. They've already bought into it. They've invested in it. And once they've invested, at the margin, they're willing to pay a lot more to keep using the technology than they would have agreed to pay in an arm's length bargain. But arm's length bargains aren't really possible in this space. Everybody's kind of forced to adopt the technology before all the licenses can be determined. That's just a practical constraint. It's not a policy decision. It's just we can't really do it any other way. And so this creates this risk that firms may have something like monopoly power that they can exploit by enforcing these patents after people have invested, right? And so sometimes there are concerns about like firms might hide the fact that they have patents, essential patents or something like this, and sort of lure firms to adopt their technologies, and then they might like come out and pounce and say, "Here's my patent." So it's that's definitely it's a really important area in the sense that a lot of like really important technologies are governed by these institutions and these patents. And so, I hope that gives you a little bit of sense of some of the issues. There's a lot more you could say, but that's a little summary of kind of the key concerns that we have.
Okay, let us then revert to or continue our conversation about the role of judges in adjudicating hard cases, hard antitrust cases. And we have a recent example with U.S. case on Remedies, U.S. versus Google case, where some people say that it is a step back, perhaps that no divestiture is being eventually proposed. Others say that the remedy is still quite harsh in terms of access to data. You've been dealing with this issue, and you have a paper forthcoming in the Journal of Law and Economics, Chicago, where you discuss the default settings. Is there any way for you to highlight the key messages of the paper, and also to maybe to reflect or illustrate it using this recent case which most of us are familiar with?
Yeah, so my paper is mainly just about this question of, can these search engine defaults really be an anti-competitive strategy? Is it something we should worry about? And that is the question that the court decided a year ago when it assessed liability. But I'll talk a little bit about it. So with a default setting, like you pull out your phone and you say you have an iPhone, you pull up Safari and you type some query into the search bar and you hit go. So by default, it's going to be executed by Google. So that's what a default means. You can change it through your settings menu. It's not that hard. And that is really one of the key challenges of this case, is trying to figure out, okay, is a default really something that could significantly impair competition if it's not that hard to circumvent the default setting? Right. So what the paper shows is that because of there's this sort of network effect like process in the search engine market, which is basically that the more people use a search engine, the more data you get about user activity, which you can then use to improve the search engine. So it's a little like network effects in the sense that when more people use your product, it gets better. It is this process, which I called algorithmic learning in the paper. It's a sort of learning process that can allow defaults to be anti-competitive, even though it's not maybe that hard to change the default setting. Okay, and so the paper goes into a lot of detail on different effects of defaults, and sort of, it shows they're not always bad, right? When little firms get some defaults, that can be a good thing. It can stimulate competition. Some amount of defaults by big firms can be good too. One of the main messages is that sort of the point where you would be most concerned is basically what happened in the Google case, which is where you've got a dominant firm that has really broad default coverage, meaning that a large portion of all queries by all people in the market are sort of falling under that firm's defaults. And so I think that the court was right to find liability a year ago. However, I never thought that a breakup made sense in this case. So now we're really shifting gears, right? So the question of whether there should be liability is quite different from the question of like, what should the remedies be? And it was just yesterday the court released his decision on remedies. A lot of people, especially sort of people in the populist antitrust camp, thought that there should be a breakup, that Google should be forced to divest Chrome. But it's not a case where where there's a really obvious need for divestiture. So normally a breakup, like the classic case where a breakup like would make a lot of sense, is where you've got a dominant firm engaging in some kind of like unilateral conduct that's really hard to police. So like the breakup of AT&T, everybody knows about that. It turned out into like all these baby bell companies that grew into firms like Verizon. AT&T was just unilaterally refusing to interconnect its own telecom network with rival networks, purely unilateral. And so it's hard to police that. It's hard to like constantly be on AT&T's back and making sure that it's, are you being accommodating of your rivals? That sounds more like regulation than antitrust, right? So that's hard. And so as a practical matter, a breakup can be the easier thing to do. But this Google case, it's all about agreements, contracts, where Google pays billions of dollars to companies like Apple to get defaults. Well, contracts are, you can enjoin them, right? You issue an injunction and terminate the agreements. And so you don't have this same concern about like having to regulate unilateral conduct. And so then there's just not as clear a need. It doesn't seem as reasonably necessary to address the conduct at issue, right? Now, there are some people who say, well, you should just break it up for punitive reasons, like as a punishment. But I don't think you should, risk causing harm to the market and to consumers, like just to prove a point, right? I think it would be better to implement strong remedies other than breakups, where you can feel more confident that these remedies will actually enhance competition. And breakups divestitures often don't do very well, right? There are lots of examples where the divested businesses are bought by some company who thinks he can run this business unit and really can't, and then it just fails, right? When you separate a division from a bigger company, you have to cut off all of these. It's kind of like transplanting a limb, right? You've got all this connective tissue that you have to cut. All of these relationships between this business unit and the rest of the company that just aren't there anymore. And that leaves a lot of holes to fill. And like, there's no guarantee that that's going to go well when you transplant this business unit into a new firm, right? Another concern is that who's going to buy it? Is it just going to be some other tech giant? And how do we know that they won't just leverage Chrome to do, some other anti-competitive thing, right? Like, there's not a whole lot of people who would be potential buyers of Chrome. Probably all the companies that would be potential buyers are like OpenAI or other major tech companies. And so it's really not clear that we would be better off by switching Chrome from one tech giant to another. I think the better approach is just to say, okay, we think Google did something bad. We need remedies that terminate that bad conduct. But we also want remedies that stimulate competition. And the court did award some remedies like that. I think there are things that legitimate complaints that you could have about the remedy decision, which I'm happy to talk about if you like. But I think that the court's refusal to issue a divestiture, I think, was the right call.
Let me pause here on remedies, and we can identify two types of remedies which could restore or boost competition. The first would address the end users with a choice screen, and many people talk about the behavioral biases and how dark patterns and stickiness of choice is difficult to change, and you have hotkeys and other means to somehow circumvent or minimize the switch from the end user side. And another type of remedies which has been also considered here and has been partially approved by the Judge Mehta concerns the access to data, to data which allow to tailor algorithms and adjust, and not all data, but significant part of this data. So which type of remedies, in your view, maybe combination of both, appear to be more appropriate in this case?
Yeah, so, most of the economists who have thought about this problem have come to the conclusion that choice screens are not likely to be that helpful, and that includes me. And what's interesting is that all of these studies have come at the problem from a lot of different directions and reached the same conclusion for sort of different reasons. There's a recent experimental study that finds that choice screens are not very helpful because they basically just don't do anything. Like, everybody just picks Google anyway. So what in my article, my article looks at how defaults by small firms, like rivals of Google, help to encourage investment and innovation by smaller companies. And so, a choice screen eliminates defaults. But what you might want to do instead is allow small firms to get some defaults, not really broad ones like Google had, but to get some defaults as a sort of reliable source of distribution. And this, it turns out, can really benefit, lead to more investment and more competition in the long run, right? And so this is actually a very, it's in some ways not a very new argument. It's the same kind of argument that courts and economists have made about things like exclusive dealing for a long time, that exclusive dealing can help to facilitate investment in some cases. So that, you know, that's my view on choice screens, is that probably we don't want a market that is just choice screens, that there are some benefits to allowing firms to have some defaults. We just don't want them to get super broad, because at that point you've got one firm that's got this really large systematic advantage over everyone else, and then that can have a really adverse effect on investment by basically everyone other than the dominant firm. And then you've got this other set of remedies, which are like different types of compulsory dealing, right? Like Google has to share, you mentioned data, right? So another really significant remedy of this type, which the court ordered, is that Google has to let smaller rivals copy its index, right? So an index is incredibly hard to build. It's what, you know, the cost of building and maintaining an index is one of the main barriers to entry in the search engine market. It's just an index is basically a map of the whole internet, right? And so, you know, the fact that rivals are going to have access to this index is going to eliminate a significant barrier to entry, right? I'm not expecting there to be like 10 search engines in the, like thriving search engines in the market, but I do think that this kind of thing can help to stimulate competition, and that it could be helpful. So I think that those remedies were, you know, are definitely a helpful step. The court did something a little unusual though, and it said that Google can continue to pay all of these companies for defaults. It puts certain limits on these agreements, but it doesn't actually limit how expansive they can be in the aggregate. And so there is, I think, a legitimate concern that Google might be able to continue doing, you know, at least in large part, the same stuff that got it in trouble under this decision, which of course could prevent these other remedies from actually, you know, solving the problem. So that is a concern that I have about the decision.
And speaking of these two types of remedies, the alternative or the refined version of the first one being a kind of partial default to some segments of market. Do I understand this correctly, or that one of the solutions would be to somehow to say, okay, we have small search engines, they are in a nation state, they are doing the first baby steps, just give them 0.1 defaults, using roulette or any other technique, rather than just giving them the opportunity to win, and then basically they will continue losing this in this choice screen. Just give them X% of all defaults in your ecosystem. Is it the solution, and would it be implementable if I understood it correctly? Well,
so it would be hard to do exactly what you're saying, because most of the defaults are controlled by firms other than Google, right? Like Apple. Apple controls the Safari default. So a judge in this Google case can't order Apple to give the default to a rival, because Apple is not a party. But I think you're right, though, that what we would like is for small firms to have access to some defaults, right? And so now there will be people who will say, well, that can't be good for consumers, because defaulting to a less popular option can't be good for consumers, right? And that in a static world would be true. But let me give you an example of why I think giving defaults to rivals is actually good. It's actually more of an analogy. So there's a really good paper on exclusive dealing in video games by an economist named Robin Lee at Harvard. And so what he does is he looks at so video game consoles like Xbox and PlayStation, they have exclusive rights over some games, right? And so a lot of that is exclusive dealing, where they just they pay someone to make their game exclusive. And so you could say, what you could say in that situation is like, okay, Xbox is much smaller than PlayStation in market share. It's much less popular overall. So you could say, well, look, we would never want to let a game be exclusive to Xbox because now you're confining it to a small portion of the player base. That could never be good. Well, what Robin Lee shows in this paper is that these exclusives play a really important role in stimulating entry and competition in the long run. If you got rid of all exclusives, PlayStation, the market leader, would be the main beneficiary because its rivals can't really get any customers to pick them if they don't have any exclusives, right? So you tolerate exclusives because it gives you competition in the long run. It gives you entry, it gives you investment. If you just look at it through a static lens, you're really going to miss some very important effects. And it's the same with defaults, right? If you just pretend that the search engines that we have now, that's what we're stuck with forever and they'll never get any better or worse, then yeah, you would not want to let small rivals have defaults. But if you want the market to get more competitive, if you want rivals to have incentives to invest, then yeah, you want to let them have access to some of these, to this better distribution channel.
And on the second type of remedy, when you read the materials available on this case, it looks that Google mentioned on several occasions that the access to what I call data, to indexing, not ranking though, is being somehow partially orchestrated or supported by Microsoft. Supposedly DOJ has received kind of outsourced prudently some of the technical skills to Microsoft, and this kind of mechanism Google was very critical about. But do you think it is normal to have this, or is it common in antitrust, in the US antitrust, to have this technical committee who would be somehow deciding on a continuous basis who will, under what conditions, will access to indexing and other essential elements, or it is an innovative remedy in itself?
I don't think it's unprecedented. So we don't have a lot of big Section 2 remedy decisions because it's really hard to win a Section 2 case. But so I don't really have a list of examples to give you, but I don't think it's a terribly unusual thing for the plaintiffs to ask for. And in particular, in a case like this, where you've got kind of a lot of different behavioral remedies to manage, it makes sense from a practical standpoint to have this independent committee to help the court and to help you basically, yeah, to help the court. You delegate a bit of authority to this committee so that the court doesn't have to be running the whole show, because that's not a realistic scenario, right? So, I think it's something that makes sense, and probably I don't expect that aspect of the decision to be very controversial. Other elements of the decision, of course, will be.
And it's a good time for me to ask you a question about the type of enforcing of proto-competition rules which emerged in the European Union and in the UK in the context of digital markets, namely the DMA and its UK broad equivalent, DMCC, Digital Markets Competition Consumers Act, where the philosophy, the rationale of these approaches is to give much more discretion to the enforcers, and thus their mandate is becoming broader. They are not only just policing the market, protecting them against anti-competitive infringers, but they are somehow co-designing the markets using kind of broader political public policy mandate, perhaps, or maybe according to those who've been proposing the very idea. Now it's refined in a less bold and categorical fashion. But do you think that this metamorphosis, this change of the very mission of the public enforcers is a helpful tool to increase more sophisticated challenges, or to face more sophisticated challenges, or it is a kind of ultra virus and it will not develop effectively in the following years?
Yeah, I think so. I kind of waver on this question. It's sort of like, a dictator can be a good political system if you have a benevolent dictator. Giving a lot of control to one body regulators, a lot of unilateral control, is good if they have good policy ideas. But if they have bad policy ideas, then it can lead to lots of problems, right? So there are a lot of trade-offs, right? Like the European system, even before some of this recent legislation, has always been a little bit more like regulation than the American system, which is almost entirely through regular courts, right? We don't have it's not as regulatory in its structure, and that makes it slower. That makes it less nimble. It means that we can't be as hands-on in our remedies. Okay, so there are some downsides, but it also means that you don't have to worry as much about like one political appointment doing a lot of crazy stuff, because no one person and no one body, small group of people has that much control over the system, right? Like even the FTC and the DOJ, they can only bring cases. They're subject to the same antitrust doctrines as everybody else, right? So there's some question about like, does the FTC have rulemaking power? But at present, it does not seem that they have expansive rulemaking power, right? So I think that I'm not really sure which system is better. I guess I would just emphasize that there are some important trade-offs between them.
A hypothetical question in this regard. Imagine that US would be a second tier a group of countries in terms of as far as digital markets concern, and because this is a sentiment many Europeans have, that the system that we have very strong consumers and we are law-abiding entity, and yet we are not benefiting from digital markets in terms of the architecture, in terms of infrastructure, as much as the United States and China, perhaps, and maybe India and maybe some other jurisdictions do. And thus, even if the purified or puristic approach to antitrust has many reasons to criticize us, we have a kind of a very vibrant challenge to face. And perhaps even if we don't know how to do this, perhaps a more proactive approach to regulating competition in digital markets, and maybe even digital markets themselves, we are doomed to make our hands dirty. Again, we don't know how, but is it a kind of a binary choice? Is it a misleading choice, which I just portrayed? Is the situation different, or how would you describe it?
Sorry, maybe you can clarify. I'm not sure I followed the question.
Okay, so my question is, one might say that it is easy to adhere to classical economic approach to antitrust as far as digital markets concern, being in the United States, because US digital markets are fine, they are doing well, they are trendsetters in this global digital race, whereas Europe has the feeling that we don't have our own EU tech, and we are somehow we are decreasing our impact in this global digital race, and thus maybe more proactive, more regulatory steps are the only opportunity for us which is left to speed up and maybe to accelerate and catch the trend-setting nations.
So I would think that that would require the EU to do less regulation to encourage more firms. Is that what you mean?
That's your normative answer, because others would say more regulation would encourage, would shape, or integration of competition policy with industrial policy would allow to build. Some would say European champions. Others would say more competitive markets in Europe.
I see. So yeah, that's interesting. So I think that so I'm not an expert on this subject, but I know that there is a lot of suspicion out there that Europe's dearth of attractive tech companies is fueled at least in part by an excessive regulation, right? Which could be true, and it's not all competition regulation. For example, it's like far costlier to fire someone in the EU than in the US because of various labor protections, right? Like, so a company like Facebook that's constantly restructuring, it would be like immensely expensive for them to operate in the EU. So, it's not all competition regulations that are driving this. I suspect that some of this is probably true, but there are also probably network effects, right? Like, there's a reason that all these companies get together in Silicon Valley, right? There are some network effects there. Probably both of these things contribute. I think that, the EU probably, I think from my perspective, the EU is probably a little over-regulated. But I know reasonable minds could differ on that. And we could probably spend all day and not even really scratch the surface of that, but that's sort of my instinct.
We are approaching the end of the hour, and we still didn't the acronym AI has never been mentioned yet during this conversation. So let me invite you to reflect upon this, I don't know, tectonic issue with so many different trajectories of the discussion, but please select those which are most relevant for your research.
Yeah, so I think I think there's a lot of people who assume that these AI products, like the chatbots, the LLMs, like ChatGPT, those guys maybe present a big antitrust concern. That does not seem right to me, because they don't have those markets are not subject to network effects in the same way that like platform markets are. And so, like, when you think about big tech, most of the companies we have in mind are platforms. And those markets really are pretty much destined to be concentrated due to network effects. But this is not the case with a lot of these AI products. Like, the barriers to entry aren't necessarily that high. There aren't necessarily big network effects. So to the extent I have concerns about these markets, it's less about competition than like, what's it going to do to society, right? So that's sort of one side of this. I do think that there are going to be some relevant sort of AI issues. Like, so for example, what we're seeing now a lot of work that has to do about like mergers motivated by data, which are sort of spurred by AI products that run on data, and sort of how the AI sort of reliance on data can encourage different types of anti-competitive practices potentially. So I'm writing a paper right now with some other guys on data spillovers that we see in lots of AI related markets, and how might these incentivize things like tying arrangements between different products, right? So I think that we will see some interesting stuff like that. But I think it's really hard to be categorical about AI, right? I don't think if someone says AI is going to be a nightmare for antitrust or it's going to be irrelevant, that person is probably like not worth listening to, right? The truth is it's going to be very nuanced. I think we're going to see some areas where it matters a lot, but I think we're going to see a lot of AI products where there's really not a big antitrust concern at all, and it's going to be kind of a mixed bag.
Let me finally ask you, Erik, invite you to provide recommendations to those who just at the beginning of their antitrust career, students who study competition, antitrust law in different jurisdictions.
So I think that it's a great time to get into antitrust. It's a really hot topic right now. Demand for antitrust work of all kinds seems to be up, right? That's lawyers, economists, academics. So I think, it's also a really fun time to get into it because there are all these new things for us to think about with, tech and AI and all that. So I think that it's a great time. And I think that, anybody who's interested should look into either studying economics or law, one or the other. Antitrust law to get the background that you need. But overall, I'm always very bullish about antitrust, and so I think it's a great time to get in.
Erik Hovenkamp, thank you very much for sharing your ideas with all of us.
Thanks for having me. It was great to chat.